We can go
Sorry.
ahead, ma'am.
Okay, sorry everyone. Actually, there is some network problem. I don't know how how it has occurred now. So basically, we will
No
start with the
issues, ma'am.
presentation. Yeah. Basically, topic is patent, its importance, and filing basic procedure. Okay, what is patent now? Why they are important? Next. So basically, can presentation second next slide.
Next, मेरी तरफ से next ही है मैम. नहीं दिख रहा है क्या? Okay.
नहीं इसके बाद हाँ right. So basically we were in on this topic कि if we have developed something, if we have some idea or we have developed something, some any project, then our concept कि what shall we do? Shall we file a paper? Shall we publish a paper? Or shall we start manufacturing? Or now the question is, how can you protect your idea? You should apply for a patent. Only idea cannot be protected until and unless you develop it into an invention. Yeah, next slide. Yes. So for an invention to develop, it should solve there has to be a problem which we are solving. So if you have a solution for that problem, invention again, if invention अब हमें patent करना है कि how to patent this invention. So for patenting, invention should fulfill the following criteria. It should be novel, that is novelty should be there. It should be non-obvious, and industrial application should be there. And it should be patentable territory in which you are living. Next slide. Next. Yes. अब जैसे मैंने बेसिक बताया कि what is criteria for patentability? It should be novelty. That is, novelty is it should be new, not known by others. That कोई invention novel कब होता है? It is novel only once it is not disclosed in the prior art. मतलब I have some idea, I have an invention I have developed, but it should not be present before to my development. Prior, it should be new, that no one has think about it. It should not be disclosed in the prior art before the priority date. Priority date is like the date of our filing of the patent application. It should not be anticipated. That is, public should not have the knowledge about it. Or it should not either oral or traditional knowledge. Basically, traditional knowledge like हमारे दादा दादी पुराने लोगों traditional knowledge like neem, haldi. Everyone knows about the qualities of neem as well as haldi. So these are covered under traditional knowledge. So if it is also covering under traditional knowledge, then also you cannot say that it is new or novel. And public knowledge, everyone knows about it. General public is aware about it. Orally आपने कहीं किसी को बोल दिया, and you are like काढ़ा, nowadays because of the COVID everyone is saying immunity काढ़ा. So it is everyone that, so it is not new. Second thing is inventive step. This is the main, actually novelty तो है ही, but inventive step is also a very major important factor in the patent. Normally nowadays, since we are dealing in patents, maximum objections, 90% objection comes in the inventive step only. Inventive step, that is non-obvious to the person skilled in art. Non-obvious in view of art, that is, it should be technically advanced, as well as economic significance should be there. It should be cheaper. Agar any product which is coming in the market and you have developed the same product, but it is cheap in cost. So, or then also you cannot say कि भैया ये तो my product is sasta. Basically, it's like cheaper than the other. No, it should be both technical advancement or both. Industrial applicability, that any invention which can be produced on a large scale and large mass can benefit from that, then only it is patentable. And last may basically the local laws. Local laws means the country like India, US, other countries. So it should be patentable. The subject matter which we are going to patent, it should be patentable under those local laws. And in India, for India, India, we have a patent, we have a section 3 of Indian Patent Act, which says that some inventions are not patentable under section 3. We will run through it next in the next slide. Next slide. Like prior art. What do you mean prior art? प्रायर मतलब आज से पहले, मेरे करने से पहले, प्रायर पब्लिकेशन इन द फॉर्म ऑफ बुक्स, जर्नल्स, आर्टिकल्स, थीसिस, मैन्युस्क्रिप्ट, or any patent. It should, the subject matter is covered in any patent or in the design. Like that's why we say if you have some invention or if you have developed something, just start filing a patent. Don't go for public. Like no, generally we have the people which come to us. Generally, we have people which come to us saying that, see, I have published a paper in 2008. Now I want to do my patent. So obviously, because it is already in the paper, so you cannot publish. It is a prior publication. Oral presentation, like since I have developed something, we go into meetings or any communications, we just say it orally to someone. That's why we say, if you have developed something, you have some idea in your mind or any invention, please don't open it. Don't say it in the public, because no someone can catch it, or someone can record that also. And then prototypes or samples, any prototype, like any inverter is present, prior use or public use. Anyone is using it before you, public is using, and prior claim. Next slide. अब anticipation, what are anticipation? Exceptions है basically कि कोई invention, like we are saying prior art, prior anticipation, but कुछ भी invention, any invention which is published before 1912, that is January 1st, January 1912, तो वो published है, तो वो exception में है, so it cannot be considered as a prior art. And it is obtained from applicant or published without his consent. Suppose someone takes from me and published it, it will not be a prior art again. Any invention which we have communicated to the government for investigation purpose, again it will not be a prior art. We have displayed it or used with the consent of the inventor and industrial exhibition may, and we have notified the government and published, so then also it will not be a prior art. It will not be considered as a prior art. Next slide. Again, there will be no anticipation. वही कि any inventor has read it in the learned society. Inventor has अपनी बात को किसी के सामने रख दिया, बोल दिया. But it should be within and file the patent application within 12 months. So that's why we say in India, if we have developed or filed it into published or any transaction in society, inventors जाते हैं basic. Am I audible?
Yes, ma'am. Yes, we can hear you.
Yes. Okay. So basically, in case like because we have developed something, we have developed some project or research, we published an article, or an inventor is just giving in the conferences, in the seminar, in the school itself, in the college itself. So and then he just filed a patent application within 12 months from such display or exhibition. So then it will not be considered as a prior art. So that window is open, that 12 months time window is open for inventors. If he is publicly worked in India for reasonable trial, like any inventions related to medical devices or any on the trial, whether it is workable or not. So if and trial ke liye invention hai within, and we have filed the invention within 1 year of such trial, then again 12 months window is open. Or we have के बाद, so definitely it is also published बाद में, so it is also an exception to anticipation. Next slide. So for example, as I was telling, the traditional knowledge, determining patent, US has taken this patent, which was granted in 1995, and see, it is related to and it is a traditional knowledge. Next slide. See, these are the prior arts for turmeric in Urdu. Next slide. Next. Again, it is in English. See, it is written here, haldi curing back. Yeah. यही वाली बस. It cures jaundice, analgesic, anti-inflammatory. तो ये पहले से ही लिखा गया था 1879 में उर्दू में लिखा गया था. And it is also traditional knowledge. Next slide. Next. Yes. So उसपे see कितने patents डाले. Basically it is revocation. So turmeric patent which was granted by USPTO, it was revoked with the 32 prior art citations finally cited. So there were so many prior arts which were saying that turmeric is a wound healer. So in Urdu, in any different languages as well as the traditional knowledge also. So patent, and all the claims were, next slide. Yes, next. So all the claims revoked the USPTO patent and finally it was revoked. Next slide. Slide. Yes. Back, हल्का सा back. Yes. इसमें दोनों में ही क्या प्रॉब्लम, क्या फर्क हुआ है? कुछ नहीं हुआ. बेसिकली इट्स लाइक द salt is सोडियम की जगह पोटेशियम सॉल्ट आया. So ultimately nothing has been changed. You have just changed the salt. So is it patentable? No, we have not. It is not patentable. Next slide, please. Next slide. Now, as we have told the inventive step, is it no? It is non-obvious. That is, it should, in the light of prior art or economic significance, it should not be obvious to the person who is skilled in art. If the person is in the chemistry domain, if the person is in computer domain, so they should see that it should, yes, ये तो मैं भी कर सकता था. Once they can say कि ये तो मैं भी कर सकता था. What is new in it? What is inventive in it? So it should be technically advanced in the light of prior art or should have economic significance. Next. Now, once when we are discovering, when we are saying, when we are just solving the problem, whether it is inventive or not, so the question is there an inventive step? So, लेकिन inventive step तभी आएगा basically once the invention is novel. If the invention is not novel at all, so there is no question of inventive step. So first is novelty. As we have discussed earlier, it should be novel, that it should not be present in anywhere. But if the invention is novel, then whether it is inventive or not. So would a person of ordinary skills, ordinary skills, any person should have thought of this? So if the answer is no, then the invention is non-obvious. When the invention is just automatic or extension of the prior art, the invention lacks inventive step. Next. See, for destroying the inventive step, more than one document can be cited. But for novelty, only one document is enough. If suppose my invention is having 4 elements A, B, C, D, and another invention and all the elements are present in different patent applications, so there is no invention. I've just done what I have not done anything. I have just combined them together. So when 2 or more documents are cited, the documents should be considered together and not separately. It should not be that I say कि नहीं इसमें ये है उसमें ये है. No, it should be together. So this is highly subjective issue in deciding whether the invention is inventive or not. Next. Now indicators, it should be surprising effect should be there, long felt need, no one has thought of it. In fact, others have tried but they have failed, and it is cheaper and more economical also. Next slide. For example, the Kilta case. It is a very good case. In this, patent was granted in 2005. It is a device for manually hauling the agriculture product. So this Dhanpal Seth ne banaya tha. So it is a bamboo. Basically, if you can see this, these product, this टोकरी it is made of a bamboo. Next slide. See, अब next time उसने क्या, दूसरी पार्टी बेसिकली नीलकमल प्लास्टिक ने क्या किया, उसको रिप्लेस कर दिया विद द बैम्बू को रिप्लेस करके प्लास्टिक में रिप्लेस कर दिया, प्लास्टिक के वे, तो इंजंक्शन डिनाई हो गया. इट वाज सेइंग दैट सब्स्टिट्यूशन ऑफ बैम्बू विद प्लास्टिक इज नॉट अ न्यू इन्वेंशन. व्हाट यू हैव डन इज सिर्फ इंस्टेड ऑफ बैम्बू आपने प्लास्टिक लगा दिया, चीज तो वही है. So device developed as a result of traditional knowledge, because bamboo को इनकी knowledge पहले से knowledge थी इस बारे में, and you are just duplicating the product. It is not an invention. Hence, there won't be any injunction available in this case. Next. Next slide. Now, as we have talked about the non-patentable inventions, इससे पहले पहले एक back slide. Yes. So section 3 basically it says about the non-patentable inventions. So there are many section A to N where it says frivolous invention, any machine which is giving 100% performance. No machine can give, because machine ultimately will not be giving it can be give 99% but not 100%. Any invention which is related to public order, against the public order, morality, any invention of killing any person, मतलब like कोई भी इन्वेंशन जो कहता है कि दूसरे को मारना है, बेसिकली इट्स लाइक एनी रिलेटेड टू मोरालिटी और इंजीरियस टू पब्लिक हेल्थ, इट इज नॉट पेटेंटेबल. If you have developed some, you have just discovered any scientific principle, whether it is living or non-living, occurring in nature, Newton's law, discovery of any microorganism, it is not patentable. Next slide. Yes. So section 3D is important. Basically, it says that if we were changing the new form of a known substance, which does not result in enhancement of the known efficacy. See, any substance is present, but it is not enhancing the efficacy or any new property of any machine or apparatus, which result in a process of new product or at least new reactant, is not patentable. For example, new use of aspirin for skin disease, mere new use of neem, they are not patentable. Admixtures, mere admixtures, if we are adding salt plus water and we are saying that it is salty water, no, we cannot have it patentable. Similarly, solution of sugar and color in water to form a soft drink, it is not patentable. Next. ऐसी basically arrangement of thing, arrangement or rearrangement, or we are just arranging the parts here and there and then combining the devices which for working independently is not patentable. For example, a bucket fitted with torch, an umbrella with fan, a clock and radio, they are not patentable. Agriculture, horticulture methods, that is cultivation methods, improvement of soil, they are not patentable. For then in section 3I, which is most important, which is method of treatment. In India, any method which is related to the treatment of humans or animals is not patentable. Any surgical processes, removal of cancer, tumor removal, nothing is patentable. Next. Plants, for example, plants and animals, they are not patentable as a whole, as any biological material which is processed is not patentable. Next is a mathematical model. Section 3K is more important because we are nowadays it is a computer area, and we are in a normal day-to-day life, we are discovering any new computer program or any business method or any mathematical method. It is not patentable. Section 3K, it says a computer program per se or algorithms, they are not patentable. But computer program is patentable if it is enabled with a hardware, that is, it is showing any technical effect. So computer program, like any website, you cannot patent a website, but like in a machine, you are putting a computer program like sensor, it is patentable. So computer software program by itself is not patentable, but combination of a hardware along with a software is patentable. If you want to have a computer program, then it is only covered under a copyright. Like any written submissions, written thesis, literary work, music, dramatic, artistic work, they are covered under copyright. It's not covered under patent. Next. basically a mere scheme of any scheme or any method of performing an act, any playing a game. How I'm playing the game, it is not patentable. Solving a crossword puzzle, again, a presentation of information, how you are presenting the information, symbol, diagrams, spoken words, they are not patentable. Integrated circuits, again, they are not. Topography of integrated circuits, again, they are not patentable. Traditional knowledge, 3P, that is again with any patent invention which falls under a traditional knowledge is not patentable. Any invention which relate to atomic energy again is not patentable under section 4. So like if any invention is the inventions related respect to uranium, thorium, or graphite, they are not patentable. So in section 3 and 4, 4 is related to an atomic energy, which is not patentable, and 3 covers section 3. Now, what exactly we are talking about patent? हाँ बस ठीक है, okay. What is patent actually? Patent क्या है? So what is patent? It is actually a techno-legal document. Why we say it is a techno-legal document? Techno means technical information, and legal is legally bound. So that's why we are saying it is a government issued techno-legal document. Technical disclosure हम देते हैं, and then legal instrument government ने में दिया that grants us exclusive right for an invention. Basically, it's for a limited period of time. That is for in India, it is for 20 years. To the given to the patentee या patent जिसने किया है inventor and applicant. Okay, in exchange of full disclosure, you have to disclose your invention in return disclosure of the invention, and it within a territory. That is, suppose I have filed the invention in India, so I will get in India. So it should lay down all the conditions which like it should not be patent. It should not fall under any non-patentable subject matter. Should not fall under non-patentable matter. It should be novel. It should be inventive, and it should be capable of producing on the large scale. So it is again a government issued techno-legal document instrument that grants the exclusive right for an invention. So you enjoy, if you get a patent, you enjoy exclusive right on that invention for a period of 20 years. So it is exactly called as a limited monopoly right, because you have that patent in your hand, so you can prohibit other persons from manufacturing the same thing, using it or selling it, the product, or from using the patented process or without your permission. So a patent can be given also for a product, also for an invention process, or product and process both. So main important is it is a exclusive right given to you for in exchange of a technical disclosure. Next, see, it is a patent document. Technically, you provide all the things, disclosure, specification, claims to the so that public can see it, and inventor is getting the exclusive right on that part. Next page. Next. Yes. Oh, importance can basically, why should I go for patent? Because patent is not an easy job. It's not a cheap process. You ultimately are paying for patent, going for patenting. Because patent आज आपने किया, you have filed for an application, then there are different forms, different processes wherein you have to pay the fees. Then if you have to maintain the patent for 20 years, again you are paying it. Why should I go for patent? Reason, importance क्या है इसकी? Basically importance is that you enjoy the exclusivity. That is, you who have applicant, you enjoy the exclusivity and the monopoly for 20 years for that invention. You can either license your technology. If you have such a technology, you can license it to the other people also. You can give an exclusive license. Exclusive means like the person to whom you're given, he is totally bound that he is only person who is the only person who will use your technology. Non-exclusive, now you have patent, you can give it to multiple parties instead of giving it to one person. And you can also sub-license, for instance, sub-license your technology. And in here, when we are going for licensing, it's like it's not territory bound. You can give it to any other countries as well. You can this is a license thing. You can license it for 20 years or 5 years or for 2 years as per your choice. You can sell your patent. Next, old slide, back. Here you can, it's a licensing that you are having the full right on your patent also, and you're licensing it also. Next, or you can, instead of licensing, you can sell your technology, sell the patent, one time payment. You can sell it to one person. So one time you get the payment and you enjoy the rights. Royalty, you can get the royalty on your technology. They can give you the payment, so you can enjoy the royalty payment monthly wise or quarterly. It depends upon you. For example, you have seen I think all must have seen the movie Three Idiots, and Three Idiots, see how he has become the millionaire basically. Next. Now, once we are now filing procedure, basically, what are the requirements? How to file a patent application? What are the requirements for that? So, for filing a patent application, there is a process like application specification. The application specification can be provisional or complete. Provisional is, I will tell you in detail also. Provisional is one wherein you have just the idea or invention and it is not fully developed, but you want to protect it, you want to go ahead from others, so you file a provisional application. Then complete means it is having, your invention is fully developed and now you want to file a complete application. So application specification, basically there is a particular format for a patent app document. It covers title of your invention, ki invention kya hai, uska title, then description about the invention, description, then basically claims. Basically in a patent document, claims are the most important part, because you can say they are the heart of the invention. As if our heart stop breathing, is functioning, then definitely no one can survive. So this is like claims, it defines the legal scope. So as legal definition of a scope of invention. Invention claims are the most important part. Then the abstract is just a small, you can say small concise 150 words, concise story of the invention. Then ये तो specification है. उसके बाद forms, what are the various forms which are used for filing the application. Then applicant, who is the applicant? Female applicant. Now in recently what has happened is with the patent amendment act में 2019, basically female applicants को basically they have given some benefits as given to startups. Female applicant can go for expedite examinations, same goes with the startup. Fees are reduced. Then fees, normal fees we have to fill. So these are the procedure basically requirement. Next, so for how? So for application for a grant of patent is filed in form 1. Form 1 is one form which covers details of invention, applicant, who is the applicant, details, inventor details, title, everything it is covered in the form 1. Next, it is supported with proof of right or separate assignment. Now, proof of right or assignment, what is it? See, ultimately, inventors, they are since you are working, you are students, and university in which you are working, university has given you the platform or you can say the lab in which you are working, you are doing your experiments. So ultimately, all the patents, since because they have given you the place where you are doing it, so ultimately those or applicant will be university. So inventors, there can be multiple inventors. So the applicants are basically, inventors are assigning their rights to the applicant. So that is called as proof of right or separate assignment. So provisional complete specification, there it is a form 2, which form 2 it contains title and the basically details about the applicant. Again, we are giving in section form 3 is there, where we are giving about the particulars of our invention. Now inventorship details are given in form 5. Power of authority, in case you are not filing your application yourself, you are going through an agent, then it is a power of authority that is on your behalf. On your behalf, the agent is filing the patent application. Fees is depends upon the category of the applicant, whether the applicant is a natural person or it is a startup, educational institution, or it is a body incorporated, that is company. So now with the recent amendment in 2020, now government has given educational institution also a relief of fees. They will, educational institution will also be covered under natural person. So finally, all the applications, whether you are filing yourself or the agent, so it should be signed by the applicant or authorized person or agent. Next. Timelines. It is the most important. Timelines is important in the patent, because ultimately if you don't file your forms within timeline, you will you will lose the patent application. It can get abandoned also. So for filing the proof of right or assignment from the inventors, form 1, it is 6 months within from the date of filing. Power of attorney has to be filed within 3 months from date of filing of a patent application. Request for examination. It is the most important. You have filed the application, but application can be published within 18 months. It will publish on its own within 18 months. But in case you don't go for filing form 18, that is with that is time period is within 48 months from the prior to first day filing. If you don't file a form 18, then no one will examine your application. It is like saying the patent office that please examine our application, and then only they will examine, and it is within 48 months from priority date. But if you don't file it, then your patent will get abandoned. Expedite examination. Expedite examination is like you file the patent application and immediately you file for request for examination, that is form 18. That is called, and you pay the extra fees. Expedite, instead of saying like you want express examination, jaldi hamara examine kar do. So this expedite examination is done only in the case of startup, when the applicant is either a female applicant or a startup. Then once they will examine your application, they will give you examination report. Then you have to file the exam, you have to give the response to your examination report within 6 months. Then proper documentation, properly documents, timely submission of all these documents are required. If you don't basically proper documentation and timely submissions, if you don't, is must for the patents. Next slide. As we have called provisional specification. The provisional specification is a specification where we are securing the priority date. Like we should first come, sir. First come, first. कहते हैं ना, first पहले आया मैं. अगर you file it today and another person file it tomorrow, then you will get the priority. So it isn't just an application which is just accompanying the invention. Details of your invention, you can just write it and file it. And from the provisional application, you get 12 months time. That is, within 12 months, you can file the complete specification. If you don't file within 12 months, your application will abandon. Provisional application, it may be, if suppose you like directly, you can convert it also into a post dated to the filing of complete specification. The date of filing can change. You can, if suppose your 12 months time is coming nearer and your invention is not yet complete, you can post date the provisional also. That is, you can change the date of provisional application. Next slide. In provisional application, what shall you write? Claims is not included, because claims are included only in the complete specification. It can be filed in the case of divisional application, convention, PCT, and in filing is in all these cases, complete specification is mandatory. Next slide. Now, back. Yeah. What is complete? So once we are filing the complete specification, then it means you have filed the patent application completely. It is a techno-legal document. Again, it covering the all major aspects of your invention. It should describe the invention fully. Drawings are if you have any drawings, it also forms a part of specification. And most important, it should have claims. It should contain all essential elements for the grant of patent. Next. So it describes the invention fully. It So basically we are describing your invention. At the same, you're describing your invention fully, at the same time you're hiding it also. So you're disclosing the best method of performing an invention. And it should if you are using any biological material, so it should also make any reference to that deposit of that biological material where you deposit it. It should contain claims and should be contained abstract to provide technical information. So basically it should be ऐसा नहीं कि हमने डालना है. Basically its complete specification should be complete in each and every aspect. It should describe the invention fully, its best method of performance, everything. Next, like title should be precise. Start with title. It should be precise within 15 words. It should give you a fair indication of the nature. What is the invention? A title should be of such nature that it should describe your invention fully. Now, preamble. It says, it is on, again, the form 2. It states saying that the following specification particularly describes the invention and the manner in which it is to be performed. So as the preamble itself is saying कि invention describe हो रहा है and the manner also कि किस तरह से perform किया जाए. Then form 2 in the first page itself is showing the name, address and nationality of the applicant. Next. Again, then comes the second page where it says field of invention. Suppose it is in the medical device, so we are saying in the medical side. If it is in the computer side, sorry, then we are saying it is in the computer. Field is in the computer related. Then background and prior art. So invention develop ही तब होता है जब there is a need for it. So it should indicate the technology कि पहले क्या थी, what was going on earlier and what problem was there which you have solved. So it is a background. Then object, again it is showing the advantages of the invention and the objective. What is your object of doing this? Summary, it should reveal all it should be overview of the invention. Next. Then comes the detailed description. It is giving the complete picture of your invention, improvements, modifications, whatever you have done. Drawings. See, drawings again is an important part because in drawings, you are not just giving the line diagrams. There is no written description on it. You're not writing any description on the drawings. It's just whatever description you are giving of the drawings, it should be in the detailed description. Like figure 1. Figure 1 में 1, 2, 3, 4 ही है. So one is the upper portion. So you're describing the figure 1 in the description. Then is the best method of performance. If invention is of such nature that there are multiple examples, like you have done problem in so many examples, so you should provide the working examples also. Next. Again, the claims. Claims is the most critical part, as actually this is the part which gives you the right of in the grant patent. Ultimately, if something is present in your specification but you have not put in the claims, you forgot claiming it, you don't have that claims on that. So that's why it is saying it defines the legal scope of your invention, but description assists in interpretation of claims. So if you are claiming something, it should be present in the description. So it is an interpretation. The description mein to hai, and then you are claiming it. But if something is present in the description and you have forgot claiming in putting in the claims, you lose it. Abstract. Again, it is providing a short brief of your technical information, just a concise summary within 150 words. In case your invention is of nature wherein biological material, any microorganism is used, any biological thing, which is natural thing is being used, you have to give the reference of that in the specification. Next. Now, most important part is the drafting, how we can draft the claims. Drafting of claims is important because, as I have told, it defines the legal boundary, legal scope of an invention. The claims usually consist of three parts. That is a preamble, transitional phrase, that is a connecting phrase, and the body. Preamble is that starting point. Like if you have done some any water prevention device, so it is a water prevention device. There is a preamble. But how it has been developed, there is a क्या क्या उसके अंदर portions है, parts हैं, that is a transition phase consisting of, comprising of, then the body. So basically, for a patent, it should for a claim should be present. It related to single invention, or it should have a single inventive step. तो ये बहुत important है. Basically, a patent, a claim should be covering only a single invention. It should not be having a multiple inventive steps. It should be clear, fairly based on meta disclosure specification. ऐसा नहीं कि description में कुछ लिखा है, claims कुछ और कर रहे हैं, ऐसा नहीं. It should be very clear. And अगर suppose description में कुछ invention है, it should be only single invention. Multiple inventions नहीं होने चाहिए claims के अंदर. Next. So basically, how you write the claims, it should be written as single continuous sentence. It should not break down. All the essential features should be present in the claim, in the first claim, and they should be fully supported by description. First claim हमेशा हम कहते हैं principal claim और यहाँ पे independent claim. Principal claim and independent claim means मतलब बाकी मतलब it is a main claim. It is covering the portions हैं हमारे बॉडी में, what are the components जो भी present है वो सब present है, but subsequent claims जो होते हैं वो उन पे dependent होते हैं. That is subordinate claims. So principal claim, that is the first claim, should define all the essential novel features, all the elements of invention with their interconnection, and should be broadest. सबसे broad वो जो होता है first claim होता है, and then all the narrow features were present in the subsequent claims. So लेकिन but when the examiner is evaluating your claim, so each claim is evaluated independently. There can be more than one independent claim in a single invention. तो सिंगल एप्लीकेशन में मोर देन वन इंडिपेंडेंट क्लेम हो सकते हैं, एक प्रोडक्ट का क्लेम, एक प्रोसेस का क्लेम, बट ऑल बोथ प्रोडक्ट एंड प्रोसेस इट शुड रिलेट टू अ सिंगल इन्वेंशन. दे शुड हैव अ सिंगल इन्वेंटिव कांसेप्ट. नेक्स्ट, अब इंडिपेंडेंट क्लेम जो है इट इज स्टैंड अलोन क्लेम होता है. इट डज नॉट नीड अ लिमिटेशन फ्रॉम अनदर क्लेम इन ऑर्डर टू कंप्लीट. फॉर एग्जांपल, मतलब इंडिपेंडेंट claim जो है, it is a complete claim. It doesn't need anything else for support. For example, an apparatus comprising a pencil and eraser attached to the pencil. So it is a independent claim. But dependent claim जो है बताएगा भी that it should take out कि dependent claim is one that depends from another claim. That is independent claim या फिर किसी और dependent पे dependent होता है. That is the apparatus of claim 1 further comprises a light attached to the pencil. So the light which can be attached to the pencil. Back. Next slide. हाँ, इसके बाद next. ठीक है. तो basically these are the most important part. We have to take care of drafting the claims. So now claims, there can be good claims, there can be bad claims. Good claims क्या होते हैं? वही जो basically defines your legal scope of invention. The full description assist करता है in interpretation of claims. Each claim must characterize an invention by its technical features, and it should have a complete. Her claim describe a complete embodiment. Bad claims क्या होते हैं? Bad claims वो होते हैं जो कि आधे अधूरे होते हैं. Basically, it's not giving you full details. For example, a folder ladder for accessing active spaces, a medicament for treating acne. This is a title actually. It is not a claim. A method for reducing petrol consumption in a vehicle, characterized in that the vehicle operates at a reduced cost to the user. Again, it is user. It's not a claim. Yet user will immediately see the benefits of my invention. See, it is again sometimes people like these claims also. Well, this is a bad claim. Next. Yeah, example. For example, see claims. A bale wrapping apparatus comprising a wrapping table for supporting and rotating square bales and wrapping film dispenser characterized in that the wrapping table comprises, इसमें क्या क्या है, table frame है, literally spaced apart rollers हैं with at least one belt wound to provide a flexible bale supporting platform between the rollers. A drive means again a roller support also. So it is comprising what for? A table frame, laterally spaced apart rollers, drive means, and roller support means. Now dependent claim kya hai? It is saying a bale wrapping apparatus according to claim 1, wherein the apparatus further comprises a curved bale dispensing plate privately connected to the frame for dispensing a wrapped bale to the ground. So it is a, again, hai wohi first preamble is same, that is bale wrapping apparatus, but the second part apparatus, it further, this is a dependent claim on the first independent. Next, back slide, back previous slide please. For example, again a process of for treating waste material comprising mixing the waste material with an additive for causing an exothermic reaction in the mixture, using it and then dehydrating the mixture. So these are the process. This is a process claim. A process wherein the additive for causing the additive mixture, exothermic reaction in the mixture, and for raising the pH of the mixture is selected from the group comprising lime, quicklime, dolomite lime, cement dust, lime clean dust. See, now the material we are saying that on the first claim it is saying mixing the waste material with an additive. So what is this additive? We are defining this additive in the second claim. This additive can be selected from the group of so many things. So this is again, we are not defining क्योंकि कुछ भी ले सकते हैं, कुछ भी हो सकता है, but we are not saying claim. So these are the dependent type claim. So I think we have next slide. So what points to be taken into consideration is कि हमें क्या करना चाहिए, क्या नहीं करना चाहिए. We should claiming too broadly. मतलब it's like we are अगर broad claim तो ठीक है, but we are covering so broadly that you are covering the prior art also. So there you will not get any protection. Claiming too narrow मतलब बहुत ही narrow claim करोगे तो features ही तो computer can use the invention. It should be that you should claim just right. Whatever the invention is, that it is an art and it requires lot of imagination also. So you have to be you should claiming it's an art. That's a claim वही करो जो है. It should not be neither broad nor narrow. Now claiming what is not supported by the description. मतलब basically description में तो वो है ही नहीं. Basically it is not written in the description. This can and must be avoided. मतलब you are claiming something which is not present in the description. Not claiming why the client wants. Like client, like any patent applicant is saying कि मेरे को ये चाहिए, आप वो claim ही नहीं कर रहे हो. And claiming what the client does not use or need. You are claiming in otherwise you are claiming different things. So you should not be there. So I think we have come to the end of the presentation. Next. So importance क्या है drafting का? So basically importance. Now once patent में और कुछ नहीं है. Basically it's an importance how you draft your patent application. So you are not allowed to add forgotten views. Okay, once you have filed the application, तो आप basically उसमें amendment कर सकते हो. You can file an amendment in the application, but amendment will be of such nature which is the scope. It is within the scope of the invention. So if you have forgotten something, views and details of invention, you cannot file it after filing. You are stuck with what you have included in the draft of the patent application. So you cannot broaden your scope of an invention. Only the scope, whatever features you have added, you can just define those features. You cannot get protection for what is not described properly. Again, claims, as मैंने कहा, if you are not described properly, you will not get protection for that. You must claim properly what you want to get monopolized. जिस पे आपको monopoly चाहिए, whatever you want to claim it, you should claim it properly. It should be, मतलब claiming is the most important part. Next. Again, You're responsible for fulfilling the requirement. Basically, you are, because you are filing the application, so you are only responsible for fulfilling the requirement of full and clear disclosure. Disclosure should be clear, understandable, so that examiner can understand the invention. So it should be clear, and it should give each and every views, each and every detail, cover the each and every aspect of your invention. You are responsible for getting the scope of protection that the inventor deserves. Inventor, because inventor says whatever is the scope they want, they can, you should describe those, you should cover those scope within very well in your patent application. Next. Yeah. Okay. I think thanks. Any queries?
Thank you so much, ma'am. The participant, any participant, if want to ask any query, can raise your hand or can write on the chat box, or I'll unmute him or her if anybody has any query. Please ask. Somebody was raising hand in between. I don't know. I forgot the name. It was some Ritesh, I think. Ritesh, you wanted to ask anything? I think nobody wants to ask anything. So we have come to an end of this very wonderful and informative session, and we are very thankful to you, Kirti ma'am, for sparing your valuable time. In future also, if we want some help or some another session by you, we'll surely call you. And thank you so much again for coming and sharing your valuable information with us.
Thank you so much.
And thank you all the participants for joining. Sapna ma'am, you would like to say something? So here we have come.
Manvi ma'am, can we have a group photograph also?
Yeah, sure. So I would like to ask and request every participant to please switch on their video for some time so that we can capture this moment. And I have given the permission to start your video to everyone. Try Aryan if you can switch on. Everybody can switch on the video. Please capture the moment. Shlesha ma'am, please aap bhi le lena ek do screenshot. Aryan, you also take. Everybody is requested to please switch on their videos for a few minutes. Thank you, Tanu, Abhay. Aryan, you are taking screenshots. Ashlesha ma'am, आपका video on नहीं है. हाँ, yes. Mansi, Rakshit, you can also switch on your videos, please. Thank you so much. So we have come to an end. And thank you again, ma'am. So we can end up this meeting now.
Thanks.
Thank you
Yes,
so much.
Thank you very much, Kirti ma'am. Thank you. Thanks a lot.